Hi everyone, my name's Megan Risser, and my presentation for the final is about hate speech and the First Amendment. So, why did I choose this topic? The first being I'm a political science major or minor, so it was kind of hard to find topics that we had talked about. Just like I'm not a recording industry major or anything like that, but hate speech and like that topic is super interesting to me. I love the push and pull between moral and legal, so I normally try to be as politically correct as I can be, but I also know that hate speech is protected speech, and so I just think that's like a really fascinating um, kind of dynamic to explore within the political science like atmosphere. And as a kid, my dad always taught me like the hard truth. Like he always played devil's advocate, and although a lot of us don't like hate speech and it makes us really uncomfortable, I think it's important for creating a just like free market of ideas. Like we can't censor certain speech just because we don't like it. So I just think the topic is really interesting, and I think it really pertains to my specific minor. So just gonna do a little brief background on the First Amendment, even though we pretty much covered it a lot in class. So the First Amendment protects speech no matter how offensive the message may be. So it does not protect behavior that crosses the line into harassment. So, and then I wanted to bring about the fighting words doctrine because it comes about a lot in the two cases that I have. And the fighting words doctrine essentially directed is words directed at any average person that may provoke a fight are not protected by the First Amendment. So any kind of speech that incites violence. And the big question here is whether speech crosses that line or not is normally determined case by case basis, which we're going to look at. And then just a little background on hate speech. ALA.org defines hate speech as undefinable, but they kind of give a brief little summary, and it's speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or any other similar ground is considered hateful. And then in 1969, this was kind of like one of the bigger cases. The KKK hateful speech was protected, holding that such speech could only be limited if it posed imminent danger. So that's kind of an important precedent. And then Brandenburg versus Ohio. So the courts can only forbid advocacy that is directed to inciting imminent lawless action. So any advocate speech can only be prohibitive if it's encouraging people to break the law or cause violence. And then I have a brief little video for you all to watch.
I truly hope you'll step up,
Not this ad.
add your name to my list of supporters before.
Oh, the irony.
Our Constitution has more extensive protections for free speech than any other liberal democracy. And it protects hate speech. It does not protect speech that can be understood as an immediate incitement to violence. But it does protect hate speech. And I myself believe, although I understand that other people believe differently, that protecting people's rights to say abhorrent things is an important part of the protection of our right of free speech. But I understand that our students today, they grew up with instruction in against bullying in the public schools. They understand what harassment is. They don't understand why it's not okay for them to say something in a classroom or in a dormitory that someone like Milo can come to campus and say in Zellerbach Auditorium.
I want to push you a little harder, though, in this, because the question is how does protecting Milo Yiannopoulos' right to engage in what I personally actually do think is fairly hateful speech, how does that protect my rights to free speech?
Well, the question is, who's the censor? So if you determine that someone has the right of determining what is hate speech and what is not hate speech, I believe you give a dangerous kind of authority to the government. And so someone that is going to censor Milo's right to engage in what we call hate speech today might call hate speech tomorrow something that is, for example, critical of Roy Moore, or critical of the kind of bigotry that you see in some of our far right groups today.
So the danger is that one person's hate speech might be another person's valid criticism of somebody else. And since it's very hard to make the distinction, therefore we have to say, even when we think that it looks like hate speech to us, we need to allow it to make sure we protect the right of the person who would have a valid criticism that others might think is hate speech.
That's exactly right.
So I think she, and I'll talk about it later towards the end of my presentation, I think she really hits on an important aspect of hate speech in the sense that it's all about who are we allowing to censor. So if we allow the government to censor a certain speech, where does that line cross? So hate speech is protected. So we're going to go ahead. And then so I asked the question, why is hate speech so important to political scientists? And this is a quote from the ACLU, actually. If we do not come to the defense of the free speech rights of the most unpopular among us, even if their views are anti-ethical to the very freedom the First Amendment stands for, then no one's liberty will be secure. So I think that kind of drives home the point that she was making in the video. So the first case we're going to look at, both cases are found in the textbook if you wanted to follow along. The first case is Village Skokie versus I don't know if I'm saying that right, versus Nationalist Socialist Party. And a little background. So this was in the late 70s, I believe 77 through 1978. And part of the concept of permitting the freedom of speech is allowing it, whether it is speech we agree with or not. So the text kind of emphasizes that no case tested this free marketplace of ideas than this Skokie case. And it is important that speech is restricted based on its potential to inflict danger or violence and not on content. So we cannot restrict speech based on content because it does not allow for full and free discussion of ideas. So in the 1970s, just kind of like a little political background, marginalized people were still trying to fight for equality. This was a very protest-heavy era. And because of this, many white working class Americans responded with a kind of conservative populism or a silent majority kind of way of looking at things. So there's a lot of tension between that white working class silent majority versus all of these people who were protesting and fighting for equality. So the National Socialist Party of America, the NSPA, they're considered neo-Nazis, had held protests prior to the Skokie protest, but were facing requirements to post insurance bonds. And then the village of Skokie is in Illinois, and this is really important. It's actually home to a large Jewish community, including survivors of the Holocaust. So we're talking a big, very tense situation here. So the facts of the case: the Nationalist Party of America, the NSPA, announced its intention to march in Skokie, a predominantly Jewish community, and the Circuit Court of Cook County, Illinois, issued an injunction. And with the help of the ACLU, the NSPA was actually able to, they actually helped. So the ACLU typically, I don't want to say falls more left. They're set up to protect the Constitution, but they definitely have more political views. But surprisingly, this came as a surprise to everyone. They stood with the NSPA. The injunction prohibited participants from wearing Nazi uniforms or displaying swastikas. We all pretty much know what a swastika is, but I included a picture just for reference. So the Illinois Supreme Court upheld the denial of temporary suspension, and this was then brought to the U.S. Supreme Court on a writ of certiorari. And so the NSPA was trying to fight this injunction, and the Illinois Supreme Court said, no, sorry, we're not going to side with you. And so the NSPA argues that the ordinances violated their First Amendment rights. The issue in holding: did the Illinois Supreme Court improperly deny the National Socialist Party's request for a stay of the district court's injunction? And the vote was yes, 5-4, so it was a very close call. The court held that where a state seeks to impose restraints of this kind, it must provide strict procedural safeguards. So it must have, like, specific reasons why. And they also ruled that despite the memories it holds, swastikas are a symbolic form of speech. So they declare that the swastikas do not fall within the definition of fighting words, although they may cause uncomfortable feelings and a lot of trauma for members of that community. Unfortunately, they deemed a swastika a symbolic form of speech. So again, this is where, like I reiterate, as a political science, we have a tendency, there's this very push and pull between moral, like, is it morally right to be able to wear swastikas around a Jewish community? No. But is it legally right? Yes, they are allowed to. So the significance, there's an emphasis that all sorts of speech, even fascist speech, are protected, and that if a state wants to impose an injunction in the face of a First Amendment rights claim, it must provide strict safeguards, including an appellate court review. And even Nazis have protected First Amendment rights. So the next case I have is RAV versus the City of St. Paul, Minnesota. The reason I chose this case was because I wanted to kind of focus on hate speech directed towards race or religions, because although they are unquestionably wrong, the law does indeed protect them under the First Amendment. So again, I'm very fascinated in that push-pull between legal and moral. As a political science minor, accepting people's right to speak freely, even when it is hate speech, has been a very hard pill to swallow. I chose this case because it sets an excellent precedent of not allowing laws that are created based on content or rule in favor of one side or another. So the decision of this case essentially set the standard that all hate speech was protected. It also references the fighting words standard, which I've mentioned previously, the fighting words doctrine, clarifying the significance of the distinction of content-based restrictions. So, a little background. I did not realize this, but RAV is the teenagers who burned a cross on the yard of a black family. I really tried looking everywhere for, like, photos or what RAV stood for, but I could not find it. And then St. Paul is just the city of St. Paul, Minnesota, and they're fighting an issued ordinance that prohibited fighting words that were racially motivated. So this is really important to understand, is that the ordinance prohibited fighting words, but there's a very specific part of the ordinance that prohibits fighting words that are racially motivated, which is content-based. So the facts of the case. RAV assembled a cross and burned it in the fenced yard of an African-American family. The city of St. Paul charged them under this bias-motivated ordinance, which is what it's called. And the RAV, that group, argued that this ordinance is overbroad and content-based. And I have written down here, I wanted to read you guys the actual ordinance, just so you knew. The ordinance states, whoever places on public or private property a symbol, object, appellation, characterization, or graffiti, including but not limited to a burning cross or Nazi swastika, which one knows or has reasonable grounds to know arouses anger, alarm, or resentment in others on the bias of race, color, creed, religion, or gender, commits disorderly conduct and shall be guilty of a misdemeanor. So that's the ordinance. The issue and holding. Is the ordinance overly broad and impermissibly content-based in violation of the First Amendment free speech clause? The answer was yes, a unanimous 9-0. The opinion was it prohibits otherwise permitted speech solely on the basis of the subjects the speech addresses. And the First Amendment prohibits content-based regulation of speech. So, The decision was given by, the majority reasoning was given by Scalia. He gave some more notes. The regulation of fighting words may not be based on non-prescribable content. It also imposes special prohibitions on those speakers who express views on disfavored subjects of race, color, or religion, which is by definition content-based. And it's very narrowly tailored to serve a compelling state interest. So the state has given their opinion on these words and symbols and what they mean, and the ordinance serves the state's interest. The concurring opinion, they just agreed that they would have decided the issue on overbreadth grounds, and that by forbidding the categorization of prohibited speech, the court then weakens the First Amendment protections in other instances. So this is an incredibly significant case in the sense that it created the standard in which virtually all hate speech is protected. So states can't create laws or ordinances that ban speech based on certain content, which is hate speech. And it held that the regulation of fighting words, which is decided in Chaplinsky versus New Hampshire, the fighting words doctrine, which I mentioned at the beginning, it held that the regulation of fighting words by subject matter was unconstitutional. So way back, I'm actually going to go back just so you guys can see. That bullet point under St. Paul, Minnesota, issued an ordinance that prohibited fighting words that were racially motivated. So that very specific racially motivated, you cannot regulate the fighting words doctrine based on subject matter. So what is hate speech like today? So the growth of technology, this kind of hits home at what that woman was saying in the video, but in terms of technology, so who controls the delete button? Who is allowed to censor and remove hate speech from the internet? Like, what kind of bans are we allowed to have? And a big problem today is cyberbullying. So a lot of people leave comments on YouTube, Facebook, Twitter. We also face the chilling effect. So if you start banning certain speech, but not all speech, people tend to self-regulate, and that idea of the free market of ideas kind of goes away because people are less likely to share and talk, and the chilling effect goes into it. And then Twitter, Facebook, YouTube. So the interesting thing about these is these are actually private companies. So because they're private, not-for-profit companies, they don't receive government funding. They are allowed to determine, they are allowed to remove or delete comments based on their own, like what they deem to be hate speech. And the interesting thing about this that I was reading about was, in terms of ISIS, so there was a huge issue with ISIS posting like their videos of beheadings and killings on social media, and so they have like programming, like software that looks for certain words, certain things, and removes those videos like immediately. But they don't mess around with, like, for example, white nationalist speech or racist speech, because that kind of software just becomes like overbroad. Like, it's literally a software thing, so they would essentially be censoring and removing all speech from a lot of conservatives, and a lot of those conservatives would be politicians, and then it becomes political, and a lot of companies just don't want to run into those kind of issues. So I thought that was like an interesting thing to read about in terms of hate speech. And why should it matter to us? Even if you're not a political science minor, we're active media users every day. So these are things we're going to run into. I know for me, I wish Twitter and Facebook would take down all kinds of hate speech. I wish they wouldn't allow those things. But again, it also falls into that, moral versus legal kind of argument. And this idea that who has the authority and the power to say what we do and do not get to say unless it's inciting violence. And then my question for you guys is, like, where do we draw the line? So I know this is like a very opinionated matter. It's kind of a controversial subject just because some people fall more protecting the Constitution, others fall more protecting human rights. Sometimes they don't always go hand in hand. Sometimes you can't protect the Constitution to the grave and still protect human rights. Just because the Constitution wasn't made during a time when people were always necessarily protecting human rights. So my question to you guys is, where do you draw the line? And I'd love to hear about it in the comments, what you guys thought about this. So thank you for listening to my presentation. I really love this topic. I'm such a political science junkie. I love when people play devil's advocate and like really push me to, kind of decide where I stand on these things. I always have such a horrible moral versus legal battle because I think, I agree. If we give the power to the government to decide what is hate speech, who knows, tomorrow they could decide that standing up for Black rights is hate speech. So it's a very complicated process. But hopefully you guys enjoyed.